So good morning, everyone. My name is Mark Snyder, and welcome to the third annual Leadership Conference here in Washington, D.C. Beautiful, sunny Washington, D.C. When I thought about that, I had high hopes earlier in the week, but at least you can rest assured by being in here today that you're not missing out on something happening outside. I've been told we're going to have sun by the end of the week. We have a fantastic program this year, a really dense program, and some fantastic speakers and panelists, judges, former judges, academics from some of the best institutions throughout the world, existing competition regulators and former regulators. And so I think that you'll be pleased with the quality of the speakers that we have and the panelists that will be talking as specialists and as experts on the various areas in which we've asked them to come and speak and share their thoughts today. I will be your guide through the program today, and for those of you who have been to other leadership events, you know that I've typically co-hosted this event with Dr. Kirti Gupta. She can't be here with us today. She gave birth to a beautiful, healthy baby boy a couple weeks ago. And she put in an enormous amount of work to make sure that this event is a success. I'm sure we'll all conclude at the end of the day that it was. But I wanted to thank her up front for the enormous amount of work that she has put into this over the last almost a year since the last event. So let me set up the day for you, and then I'll get on with the program after introducing this morning's keynote speaker. So many of you have attended the previous leadership events and know that the purpose of the conference really has been to advance the discussion on IP policy issues from an empirical perspective. And this year, with a new administration in Washington, D.C., we thought it would be appropriate for this conference to address some of the new opportunities that we have to engage on IP and competition policy issues. And in doing so, what are the types of things, the advice that we would want to give to the new administration. So today we'll start out with a keynote focusing on IP policy, and then we'll move into a discussion on IP policy in the new administration. And then after that, we'll have a separate panel or series of panels that address some of the IP policy issues that have received a lot of attention in the past administration, but with an eye towards the future. And those panels and those discussions will center on the role of standard-setting organizations and the effects of IPR policies, international antitrust challenges, and the intersection between intellectual property and antitrust. Before I conclude my remarks and introduce our keynote speaker, I do want to deal with a couple issues. One in particular that's very important is that I want to thank our sponsors for their generous support that has made this event possible. There are several premier law firms that have been dealing with the issues that we'll be talking about today that I want to thank: Alston & Bird, Baker & Botts, Covington & Burling, Cravath, Swain & Moore, Morgan Lewis, and Sherman & Sterling. In addition, I'd like to thank our corporate sponsors, Ericsson Incorporated, Nokia Technologies, and Qualcomm Incorporated. And last, but certainly not least, the support that we have from Competition Policy International. Many of you in the antitrust industry know that it's CPI. And I'm pleased to announce that there will be a special edition of the CPI Antitrust Chronicles published that will feature today's conference proceedings. So my last item is logistic, and that is that if you're interested in connecting to the Wi-Fi network, it's open, it's museum, so there's no security. And now with that, I'd like to introduce this morning's keynote speaker. It's my pleasure to introduce to you former Chief Judge Paul Michel. I can't give a complete list of all of his accomplishments, his accolades, and achievements, or we'd be here all day long. There are a number of them that are identified in his bio within the program that you all have. But very briefly, Judge Michel has served for more than 22 years on the Federal Circuit Court of Appeals, retiring in 2010. From December 2004 until his retirement, he also held the position of Chief Judge. While at the Federal Circuit, he presided over several thousand appeals and authored more than 800 opinions, with approximately 1/3 of those concerning intellectual property law and issues. He is undoubtedly one of the most influential leaders in intellectual property law in the world. He was a frequent speaker on IP issues during his judicial tenure, and since leaving the bench, he speaks out on the national need for better patent policy and protection, and the vital but unmet resource needs of the courts, the United States Patent and Trademark Office, the International Trade Commission, and other intellectual property-related agencies. So please join me in giving a warm welcome to Judge Paul Michel.
Good morning, everyone. It is a great pleasure to be here again at this conference. It was important the first year it was held, and its importance has only grown, as we might all agree. So in our time together today, we're going to try to take stock of the health of the American patent system, measure its efficiency, its effectiveness in today's environment. It's worth remembering, I think, that the patent system and the IP system in general were founded in the Constitution. In fact, in the original Constitution, the patent and copyright personal rights were the only use of the word right. Of course, in the Bill of Rights, the word occurred frequently, but in the original Constitution, the patent right is the only right. The very first Congress enacted the first Patent Act, so we've had the system for over 2¼ centuries. And during that extended span of time, the patent system has contributed significantly to the astonishing growth in American prosperity, power, global prominence, technological leadership, and much more. In the last half-decade, however, the patent system has been fundamentally changed by outside forces. The system has been hit by 3 successive waves of change. The first wave in the form of post-issuance review of patents under the mandate of the American Invents Act. The second wave, the quartet of Supreme Court eligibility cases. And the third and most recent wave, regulatory actions and suits by competition and antitrust authorities around the world as well as here in the United States. I read recently that for many, many years, the U.S. patent system was rated by an international body perennially as the #1 in strength of all the patent systems of the world. But last year it dropped from #1 to #10. So in my view, a few years ago, it would have been little exaggeration to say we were facing a big challenge. I suggest to you that today we are facing a crisis. Even in the prior decade, the system was substantially impacted in an adverse way. First, we had eBay, which reduced the right to exclude, and for many patent owners made it a mere right to sue, and then sue again for continuing infringement. Next, we had KSR, which made invalidating issued patents even easier than before. The first case reduced the value of patents, and the second added substantial new uncertainty as to whether there even was a patent. So the system was a bit battered even before the 3 recent waves. Now I want to suggest that any attempt to assess the health of the system has to start with a clear criterion for making that assessment. So we should ask, what is the goal of the patent system today? I suggest it is this. The primary purpose of the American patent system is to increase invention by incentivizing investment. Now, most research and development efforts in today's world are very expensive. And the efforts to develop actual products and services, that commercialization, even more expensive, often requiring multiple rounds of funding of increasing size. Now, of course, there are only two streams available for this research and development and commercialization. I'll call it R&D for short. First, outside money, venture capitalists, private equity funds, pension funds, investment banks, and so forth. And second, inside funding available from those companies that have a significant stream of revenue. So both those sources can support research and development and commercialization, or be used in other ways. So the people responsible for managing those two streams of money have to look at return on investment. What are the odds of any return on the investment, any profit? What is the scale that the return may yield? And what is the time to money? There are, of course, other questions, but those are the starting point and the three biggest questions. Now, both these funding sources have many alternatives, and both are disincentivized by uncertainty. So the barometer we ought to be looking at is the amount of uncertainty. Is it growing? Is it staying the same? Is it shrinking? What is the impact on the flow of money? The two flows, I really should say. I would suggest that before enactment of the AIA, uncertainty in the patent world was already rather high. Patent litigation was slow, it was expensive, it was disruptive, it was risky, it was unpredictable in significant degrees. Some experts suggested that patent litigation was so expensive it had replaced horse racing as the sport of kings. I once heard a well-known author, Kevin Rivett to be specific, say that no one should attempt to, and no one could, monetize a portfolio of valid patents unless they had a $30 million war chest in the bank and a $3 billion capitalization. So where does that leave smaller entities, startups, and all the rest? Okay, well, how about after the AIA? Well, patent litigation is still slower, still more expensive, and still riskier and more uncertain than ever. Then we had Alice. How did that affect these criteria? Well, of course, it became still riskier and more uncertain. Ironically, as the Supreme Court shrank eligibility here, Europe and China expanded it. So that's quite a significant turnaround, I would suggest. And on top of that, trials in Europe and in China are faster, cheaper, surer, and remedies are stronger because injunctions are routine there, no longer so here. In Germany, for example, injunctions being routine almost always drive prompt settlement shortly after the fast trial. Now, as I suggested, the impact of all these recent changes is felt unevenly. The bigger, wealthier companies have a better chance of withstanding these forces than startups or small and evolving businesses. For example, university spin-offs, new biotech companies, very hard hit by the current forces, and obviously wealthy major multinationals less so. Why does that matter so much? Well, it matters because according to the Kauffman Foundation and the Census Bureau in multiple studies, in the last 4 decades in the United States economic history, most new growth has come from those smaller entities. Most major technological breakthroughs have come from those smaller entities, and most net new jobs come from the same source. And of course, those smaller companies depend critically on the outside investors, the venture capitalists, and the rest. As I mentioned, those fund managers have many alternatives, and they're attractive alternatives. So, for example, if I'm a corporate CEO, I can use the revenue stream instead of supporting research and development and commercialization to do stock buybacks, or to pay bigger dividends to the stockholders, or to spend more money on ads, or executive compensation, or many other things. The same thing with venture capitalists. They're not required by law or ethics to support R, D, and C. If they'll make more money building casinos, that's probably what they'll do, or some other expenditure. So uncertainty is driving down the incentives for both funding sources. And unsurprisingly, at least in certain technologies, outside funding is beginning to dry up. Particularly hard hit, I'm told, are the bio firms, but others are feeling the effects too. We see a significant flight of patenting now going into trade secrecy. And of course, it's understandable that people would do that as patents get weaker and trade secrets remain strong, now even stronger because they're federally enforceable as well as in state courts. So we're seeing some worrisome symptoms. Patent applications in the United States are down significantly. Patent lawsuits are down significantly. The payment of maintenance fees that supports a big part of the income at the patent office is flagging. And ironically, patent applications are going up very sharply in China and significantly in Europe. So the comparison, I would say, is a little bit worrisome. What about patent values in this new regime? Well, according to some economists who've studied the available public information, of course, most patent valuation is done privately, so no one really knows what the value is. But based on public sources, two economists have reported in multiple articles that patent values overall have dropped by as much as 60% in the last 5 years. So one of the other startling developments is, of course, patents are only enforceable in the district court and the trade commission. No one is otherwise compelled to honor intellectual property. So you would think from that that the courts are the key. But under the AIA, I would suggest that the Patent Trial and Appeal Board has become even more important than the district courts, because it's become the way station to enforcement in the district courts. You know, the AIA reviews, like Inter Partes Review, IPR, were sold on Capitol Hill partly as a cheaper, faster alternative to court litigation. We should, you all know the statistics, 3 times as many AIA reviews have been filed as were anticipated, very high levels of instituting so-called trials, very high levels of invalidating claims or disputes about the percentages, but it's high by every measure and definition. Of course, that means some suits never have to get tried. Patents invalidated, district court cases over. So in a way, that's a gain in efficiency. But in the cases where there are asserted claims that survive, it's a loss of efficiency because we've now added, since stays are now routine, 60% of the time and going up, we've added delay and we've added cost to the enforcement of a valid patent. And of course, the results have proven essentially immune to close scrutiny by the Federal Circuit Court of Appeals on review. AIA reviews get affirmed in something like 96% of the cases. So if a patent owner loses in the Patent Trial and Appeal Board, recouping is highly unlikely. And of course, there are some interesting differences. In IPRs, there's no requirement of standing as there is in district court. There's no strong presumption of validity as there is in district court. There's no need for clear and convincing evidence as there is in district court. A mere preponderance suffices. Discovery is very limited, contrary to district court. Almost no live testimony, contrary to district court, and so forth. So big differences. My own view is it would be beneficial for fairness and economic efficiency for the AIA reviews to be equalized in standards and burdens with court reviews. I don't see any justification, for example, for the broadest reasonable interpretation every asserted claim only has one meaning, one scope, and that's the Phillips scope. So why can a patent be invalidated under some other kind of scope? I just don't see the logic of that. So it may be that changes can be made in the IPRs and the covered business method patent reviews, and hopefully that will be done. But right now, the new AIA regime at least worries me. Of course, then we have wave two. Just as the pattern of IPR results was becoming clearer and to some of us somewhat ominous, the Supreme Court came along, and in the quartet of Bielski, Mayo, Myriad, and Alice, legislated, and I'm using the word deliberately, legislated completely new eligibility requirements compared to the prior law. And it did so in isolation, not in a coordinated effort with the AIA. So you have two institutions acting completely independent and crunching the patent system with no regard for the effects of the initiatives of the other institutions. So what are the combined effects? Well, it's not hard to guess because we know the mechanism. The people who control the money now have more to worry about than they had to worry about before. And so the risk of no return on investment has gone up. The risk of a small return has gone up. The risk of more delay before getting any money, even if you prevail, has gone up. The cost of asserting and enforcing patents has gone up. So how much does it matter? Well, I suggest that it matters a lot. As the video suggested, the negative results could be slower technological advances, slower job creation, lower incomes for individuals and families. That also means lower tax receipts for local government, for example, to repair the infrastructure in our country that's in just an appalling state. And then there's global competitiveness and all the rest. So the question in my mind is, can we correct the imbalances? And I think the answer is sure. We can change things both by legislation, and in fact, in the IPR context, regulations could change all but two of the controversial procedures in the PTAB. In the courthouse, there have been a lot of reforms on discovery, on fact pleading, on fee shifting for exceptionally weak cases. Now there's a prospect that venue reforms will shortly be enacted both by the Supreme Court and maybe by Congress. So I see a lot of hope of constructive change occurring fairly soon. And of course, we're in a season of change, a year of change with a new administration, and that will be explored by the coming panels. It's almost ironic, but in our society, it seems like things have to get really pretty bad before they can get better, because the politicians always lag behind the realities, and even when they're informed by experts like all of you, they still are very slow to catch on and act. But I think they're beginning to catch on up there on Capitol Hill, where the Congress and the Supreme Court sit. But I suggest to you that the needed reforms and readjustments will not happen without more active involvement from all of you, the true experts on patents, and your peers elsewhere. So we'll have an interesting day together with panels that will explore patent legislation that's pending, priorities of the new administration, another panel on standard-setting organizations and policy impacts, yet another panel on antitrust priorities of the new administration, a speech by former FTC Commissioner Josh Wright, and then panels on international antitrust and the interface between antitrust and IP. So we're in for a very worthwhile day together. It's a great pleasure to be here with all of you. Thank you so much for your kind attention.